All right, so let's dive into this.
Okay.
Partition in kind in California.
Sounds good.
We're really focusing on you today.
Okay.
You know someone who's likely a real estate attorney, probably dealing with partition cases down there in Southern California. You're probably already a pro at partition by sale.
Right.
It's definitely more common, but we're going deep on its,
Yeah.
I guess, lesser known sibling. Partition in kind.
Interesting.
Legally favored,
Yeah.
but often misunderstood.
Yeah. Yeah, for sure.
So we've got some sources for this deep dive. We've got legal rulings, articles from firms that specialize in this,
Great.
and even some insights from the Martinez Law Center in Santa Ana.
Oh, nice.
Those are the experts in this area.
Yeah.
Their website's martinezlawcenter.com. You can check that out later for even more info, but
Okay.
that's just a little aside.
Yeah.
What's interesting about partition in kind?
Well, what's interesting is we're not talking about selling the property and splitting the proceeds. We're talking about physically dividing it among the co-owners. So imagine drawing lines on a plot of land,
Okay.
each section representing separate ownership.
Gotcha.
You know, many attorneys, they're surprised to learn that California law actually favors this approach.
Really?
Yeah. Think back to the Butte Creek Island Ranch versus Grimm case. It was back in 1982.
Okay.
It kind of shook things up. It established partition in kind as the default, not the exception.
Huh. So if it's the preferred method,
Right.
why isn't partition in kind more common?
Yeah.
Our sources mention that it's all about achieving an equitable division.
Yeah,
Is that the
it's-
sticking point?
Well, it's one of the key factors.
Okay.
The law requires an equitable division, not necessarily an equal one.
Okay.
So, for example, you know, if one part of the land has direct road access,
Right.
it's inherently more valuable than a landlocked section,
Okay.
even if the acreage is the same.
Makes sense.
So the court aims for fairness, considering ownership shares. Like, if you own 75%, you'd likely receive a larger or more valuable portion than someone with a 25% share.
Gotcha. So the court plays referee,
Yeah,
weighing both the land's characteristics and the ownership percentages.
exactly.
That makes sense, but it also sounds complex.
Right.
I'm guessing this complexity contributes to partition in kind being less common
Yeah.
than just a straight sale.
Absolutely.
Okay.
Practicality plays a huge role.
Yeah.
Partition in kind makes the most sense with vacant land
Okay.
or large undeveloped properties.
Right.
It's easier to draw those dividing lines.
Yeah.
Imagine trying to split a single-family home right down the middle in the heart of LA.
Oh, yeah.
Wouldn't work.
That brings up an interesting point from our research.
Okay.
While historically, partition in kind was mostly for undeveloped land,
Right.
recent California laws have kind of opened up some new possibilities,
Yeah.
particularly with residential properties.
For sure.
And you're referring to AB 1033 and SB 9,
You got it.
two pieces of legislation that have kind of shaken things up.
Definitely shaking things up.
AB 1033,
Yeah.
for example,
Mm-hmm.
it allows those accessory dwelling units, ADUs,
Right.
to be partitioned and sold separately from the main house.
Exactly.
Okay.
Imagine a scenario, you know, where siblings inherit a property with an ADU.
Okay.
Instead of being forced to sell the whole thing,
Right.
they could potentially divide it.
Okay.
One taking the main house, the other the ADU.
Gotcha.
This adds a whole new layer of flexibility in resolving these property disputes.
That's a great example of how this legal concept can be applied, like in real world situations.
Totally.
And then there's SB 9,
Yeah.
which, as our sources explain, allows for lot splits in kind, at least in theory.
So SB 9 is more complex and, frankly, not a silver bullet.
Yeah.
It's expensive to implement,
Okay.
rarely used in partition cases,
Gotcha.
and subject to a patchwork of local city ordinances, making it kind of a legal labyrinth.
Oh, wow.
Yeah.
So it exists.
It's there.
But its impact on partition in kind has been limited so far.
Yeah, very limited.
Okay, so AB 2033 seems to have
Yeah,
more immediate practical applications for resolving disputes.
I think so.
We've got these legal changes,
Yeah.
potentially expanding the use of partition in kind, especially in residential settings.
Right.
But what about ensuring fairness when the physical division isn't perfectly equal in value?
Yeah, that's a good point.
Our sources highlight this concept called owlty. This sounds like something straight out of a fantasy novel.
It kind of does, but owlty is is a fascinating legal mechanism
Okay.
designed to balance the scales when dividing a property in kind.
Okay.
So let's say even after considering ownership shares,
Yeah.
one portion of the divided land is inherently worth more than the other.
Right.
Owlty is a sum of money paid to the owner who received the less valuable portion.
Okay.
It ensures financial equity even when the physical division isn't perfectly equal.
So it's like a built-in equalizer.
Right.
Preventing one party from being like shortchanged
Yeah.
in the division.
Yeah, exactly.
It seems as understanding owlty is crucial for attorneys handling partition in kind cases.
I think so, for sure.
But what about situations where a sale might be the better option,
Yeah.
even if dividing the property is physically possible?
Right.
So that's where we delve into this concept of substantial injury,
Exactly.
a legal term that comes into play when determining the best method of partition.
Right.
In states like North Carolina, for example.
Yeah.
If dividing a property would significantly decrease its overall value or seriously harm one owner's rights,
Yeah.
a sale might be ordered instead.
Exactly.
It's not simply about can the property be divided,
Right.
but should it be divided?
Exactly. You got it.
Oh, it's a balancing act.
Yeah.
Weighing the benefits of partition in kind against the potential for harm or financial loss.
Yeah, for sure.
That's a lot for attorneys to consider.
It is.
And it really highlights the expertise needed in these cases.
Absolutely.
And it's important to remember that the burden of proving substantial injury
Yeah.
lies with the party advocating for the sale,
That's right.
not the party resisting it.
Exactly.
This is where a deep understanding of case law and legal precedent becomes crucial.
Absolutely. Yeah.
This has been incredibly insightful.
Oh, good.
And I know our listener, deep in the trenches of Southern California real estate law,
Yeah.
is already starting to connect these concepts to their own cases.
I hope so.
But why is this deep dive into partition in kind
Yeah.
so crucial for them?
Well, here's why this matters. Even though partition in kind isn't as common as partition by sale,
Okay.
understanding its nuances, especially with the recent changes in California law,
Right.
can give you a real edge. You might spot creative solutions that others miss,
Oh, okay.
leading to better outcomes for your clients.
So it's about expanding your toolkit and being prepared for those less common,
Right.
but equally important scenarios.
Absolutely.
Speaking of being prepared,
Okay.
are there any resources you'd
Sure.
recommend
Yeah, absolutely.
for attorneys who want to dive deeper into this topic?
So the Martinez Law Center, based in Santa Ana,
Okay.
they specialize in these types of cases. They have a wealth of information on their website, martinezlawcenter.com.
Okay.
They handle partition by sale, partition in kind,
Okay.
and even real estate fraud cases
Wow.
throughout Southern California.
Okay.
So their experience is invaluable for anyone navigating this complex area of law.
I can already hear our listener jotting down that website. It sounds like a treasure trove of information
It is.
for any attorney dealing with partition cases in California.
Yeah, I think so.
We've only just scratched the surface of this topic, though.
We have, yeah.
In the next part of our deep dive,
Okay.
we'll move from these broad concepts to specific case studies,
Okay.
illustrating how partition in kind has played out in real-world scenarios.
I like it.
These examples will provide valuable insights into how the law is applied, the challenges that arise,
Yeah.
and the strategies that can lead to successful outcomes.
That's great.
Sounds fascinating. Stay tuned, because we're about to get into the nitty-gritty of partition in kind,
All right.
those real-world examples that bring these legal concepts to life.
Sounds good. Hashtag TTS, the deep dive episode 2025, Era 119, part 2 of 3.
Welcome back to our deep dive into partition in kind.
Okay.
We've laid the groundwork,
Yeah.
explored those legal concepts, the recent changes in California law.
Right.
Now let's get into the real-world application
Okay.
with some case studies.
Sounds good.
I think these examples will really, really resonate with you,
Okay.
especially given your focus on real estate in Southern California.
Yeah, for sure.
So let's start with a scenario that's probably all too familiar in your practice.
All right.
A family inherit a beachfront property, say, down in Orange County. Imagine 3 siblings. They inherit this beautiful, valuable home from their parents.
Right.
But their visions for the property clash.
Yeah.
One wants to keep it in the family. Another wants to just sell it, split the profits.
Okay.
And the third's on the fence.
Classic
Yeah.
inheritance dispute, right for a partition action.
Exactly.
In this particular case, the property was a single-family home on a standard lot,
Right.
not, a sprawling ranch that you could easily divide.
Right.
So partition by sale seemed like the most practical solution.
Okay, but I knew there had to be a twist.
There's always a twist.
What happened?
One sibling had shouldered the burden of property taxes and maintenance for years,
Oh, okay.
while the others hadn't contributed much.
Right.
So when it came to dividing those proceeds from the sale,
Yeah.
the court took this into account.
Okay.
The sibling who had been carrying the financial burden
Uh-huh.
received a larger share,
Well,
recognizing their past contribution.
that's a great example of how fairness in a partition action doesn't always mean a perfectly equal split.
Right.
The court considers the history of the property
Yeah,
and the actions of the co-owners to reach an equitable outcome.
exactly.
Okay, what's our next case study?
Let's shift gears to a commercial property dispute.
Okay.
This time in Riverside County.
Right.
We have two investors who partnered to purchase a multi-unit apartment complex,
Okay.
hoping to profit from the rental market.
Uh-huh.
As time went on, though,
Yeah.
their investment philosophies diverged.
Okay.
One favored a long-term hold, believing the property would appreciate,
Okay.
while the other was eager to sell and reinvest the profit.
Yeah, it's a classic clash in real estate.
It is.
Patience versus immediate gains.
Yeah.
How did they resolve this impasse?
They opted for partition by appraisal.
Okay.
So the court appointed a neutral appraiser
Right.
to determine the property's fair market value. And then the investor who wanted to keep the complex
Yeah.
had the option to buy out their partner
Yeah.
at that appraised price,
Gotcha.
preventing a forced sale on the open market.
So it became a private transaction between the co-owners
Yeah,
using the appraisal as the foundation.
exactly. Partition by appraisal can be a strategic solution.
Okay.
When one co-owner has a strong financial or even emotional attachment
Right.
to the property, it allows them to retain ownership
Okay.
while ensuring the other party receives a fair value for their share.
Okay, I'm ready for another dose of real-world partition drama.
All right.
What's our next case?
This one takes us to San Diego County.
Okay.
Imagine a large agricultural property
Okay.
passed down through generations
Uh-huh.
with a complex web of co-owners,
Yeah.
siblings, cousins, in-laws,
Oh, wow.
each with their own ideas for the land's future.
Oh, yeah. I can already picture the family gatherings.
Right.
Probably a mix of nostalgia and tension. How did they navigate this situation?
Surprisingly, this is where partition in kind, often perceived as an outdated concept,
Right.
came to the rescue.
Yeah.
The property's size and undeveloped nature
Yeah.
made it ideal for physical division.
Gotcha.
So the court worked with surveyors to create separate parcels, each with its own value and potential uses.
So instead of a bitter legal battle
Right.
that could have fractured family relationships,
Yeah.
they found a way to honor those connections to the land
Right.
while accommodating different visions for its future.
Exactly. It's a fantastic example of how partition in kind can be a win-win solution, preserving both family harmony
Right.
and the property's legacy.
Okay, last case study.
All right.
And I'm really curious to see what creative solution emerged this time.
Okay.
What do we got?
Let's head back to the urban landscape of Los Angeles.
Okay.
This time we're dealing with former business partners
Okay.
who jointly own an office building.
Mhm.
The partnership dissolved,
Yeah.
leaving them with a shared asset that neither one wanted to manage alone.
It's a classic post-breakup dilemma.
It is.
But with commercial real estate as the sticking point,
Exactly.
did they resort to a forced sale to untangle their interests?
Well, they were able to avoid that outcome
Right.
by embracing a strategy we touched on earlier,
Oh, really?
mediation.
Oh, okay.
So instead of launching into a potentially lengthy and expensive court battle,
Right.
they agreed to work with a neutral third party
Yeah.
to find a solution.
So mediation saved the day.
It did.
I'm guessing it involves some compromise.
Absolutely. They negotiated a settlement
Right.
that addressed each partner's financial goals
Mhm.
while preserving their business reputations.
All right.
One partner ended up buying out the other,
Okay.
but at a price they both felt was fair.
Gotcha.
So they were able to part ways on relatively good terms.
Yeah.
A valuable outcome in the business world.
This case is a fantastic reminder that partitioning actions don't always have to be adversarial.
No, not at all.
With the right legal guidance
Mm-hmm.
and a willingness to explore alternative dispute resolution methods like mediation.
Yeah.
It's possible to reach a mutually beneficial outcome.
Absolutely.
What stands out to you as we wrap up these case studies?
What strikes me is how each situation
Right.
presented unique challenges requiring a depth understanding of California law,
Right.
practical considerations, and creative problem solving. It's not a one-size-fits-all approach.
And that's precisely what we want to equip you with.
Yeah.
The knowledge and insights
Yeah.
to approach your own partition cases with a fresh perspective.
Right.
Going beyond those textbook explanations.
Absolutely.
Now, let's shift gears and delve into
Okay.
some strategic advice for attorneys
Okay.
handling partition actions. These are the tips and tricks that can make a real difference in your practice.
Yeah, I like it.
Perfect. Let's give our listener that real estate expert in Southern California some actionable advice they can use right away.
Okay.
What's our first tip?
All right. Hashtag TTS, the deep dive episode 2025-01-19, part 3 of 3.
Welcome back to the final part of our deep dive.
Hi.
We've journeyed through the complexities of partition in kind.
We have.
From those legal definitions to those real-world case studies.
Right.
Even touched on some strategies for attorneys. Now let's focus on a crucial element.
Okay.
The California Civil Code.
Okay.
And its impact on these cases.
Yeah, the California Civil Code is a treasure trove of legal principles.
Okay.
And within it lies a specific section devoted to partition actions.
Okay.
Understanding these provisions is like having a secret weapon in your legal arsenal.
Okay, so let's unpack these legal gems.
Yeah.
Where should attorneys focus their attention?
I think section 872.210 is a great starting point.
Okay.
It clearly outlines the right to partition
Okay.
and who can initiate such an action.
Okay.
Essentially, it confirms that any co-owner, regardless of how small their ownership share, has the right to seek a partition.
Call
So
now.
even if you own a tiny fraction of a property,
Yeah.
you're not powerless if you
4,
can't agree
2,
with the other owners.
nine,
Exactly. It's a
7,
fundamental protection
4,
for property
1.
rights in California.
Thank
Okay.
you.
Then we have a section 872.230, which gets into the nitty-gritty of filing a partition complaint.
Okay.
This section mandates that anyone initiating a partition action provides specific information, details about the property, the co-owners involved, and the nature of the dispute.
So it's not enough to just show up in court and say, we can't agree, let's split it up.
Exactly. You need a well-structured, legally sound argument.
Yeah.
The court needs to see a clear justification for their intervention.
Okay, and finally, there's section 872.840, which addresses the court's authority
Right.
in deciding the method of partition, whether it's a sale, in-kind division, or even appraisal.
Exactly.
This is where the judge steps in, weighing those various factors to determine the most appropriate course of action.
Absolutely. The court will consider things like the property's characteristics, the feasibility of dividing it, the potential impact on each owner's interest. So understanding these key sections of the Civil Code is essential for any attorney handling a partition action.
It's like having that legal roadmap to guide you through the process.
Yeah, I like that analogy.
Now let's shift gears and explore another tool that can be incredibly valuable in these situations.
All right.
Partition agreements.
So partition agreements are like a prenuptial agreement for property co-ownership.
Right.
They're proactive documents that co-owners can create to outline their rights and responsibilities, potentially preventing future disputes.
So instead of waiting for a conflict to erupt and then heading to court, co-owners can establish clear ground rules from the outset.
That's the idea.
Okay.
It's about setting expectations and creating a blueprint for harmonious co-ownership.
I like that.
So these agreements, might cover things like how expenses are shared, how decisions about the property are made, what happens if one owner wants to sell their share.
Gotcha. It's a proactive approach to managing shared ownership, potentially saving everyone time, money, and stress down the road.
Exactly.
And if a dispute does arise, the partition agreement can serve as a valuable guide for resolution.
It can.
Often preventing a costly and drawn-out court battle.
For sure.
Okay, so we've explored the relevant sections of the California Civil Code,
Yep.
the importance of those partition agreements. As we wrap up our deep dive, What are the key takeaways for our listener, that real estate expert navigating partition cases in Southern California?
All right. Here's what I hope they'll remember. Partition in kind, while less common than a sale, is a viable and often preferable option.
Okay.
Especially with the evolution of California law.
Right.
It can preserve family ties, allow someone to retain a cherished property, and provide a fair outcome for all parties involved.
Absolutely.
Mastering the California Code of Civil Procedure, particularly those sections related to partition actions, is like having a cheat sheet.
Okay.
For success in these cases.
Gotcha.
Knowing the rules of the game is half the battle.
Right.
And partition agreements, powerful tools for preventing future headaches.
Okay. Encourage
your clients to consider creating one.
Yeah.
Especially when inheriting property or entering a business partnership involving real estate. It's a proactive step that can save everyone a lot of grief later on.
And remember those strategic tips we discussed throughout this deep dive?
Oh, yeah.
Document everything meticulously.
Yeah.
Explore those alternatives to litigation, like mediation. Be mindful of those emotional dynamics at play.
For sure.
And communicate clearly and consistently.
Those are great tips.
These are the hallmarks of an effective real estate attorney.
Absolutely. And as you continue navigating the world of real estate law, remember it's constantly evolving.
It is.
Stay informed about changes in California law, new case rulings, emerging trends. Never stop learning and adapting.
Right.
And you'll be well equipped to handle any partition action that comes your way.
We hope this deep dive into partition in kind has equipped you with the knowledge, the insights, and the confidence to tackle these complex cases head on.
That's right.
Until next time.
Keep diving deep into that fascinating world of real estate law.
All right.
Call now 714-442-9741. Thank you.